Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the appellate are here. The defendant shall be heard.
Good afternoon, everyone. Oh, a little sparse here today. Oh, a little chilly. All right, folks, we got 5.5 hours of argument time. It's a nice day out. I don't think you guys all want to be here. Folks want to be here till that long. So that said, let's go through this calendar. Ask for the time you need. We're a hot bench, and we'll get to your issues. First case up, People versus Sterling Aguilar. Submitted. Second case up, Allen versus Thompson.
Allen, 5 minutes, please.
Any rebuttal?
No, Your Honor.
Oh, okay, 5, great. Hang on a second. 5. Ooh, that was safe.
I didn't mean to do that.
5 and 4.
Scott.
I got it.
Yeah, yes.
That's all right. Didn't hit the electric stuff. That's fine. Don't light up.
water.
Yeah, it's just water. If I light up, you know why. Third case, Mary Ann V. Submitted. Freedom Mortgage versus Miller. Submitted. Oh, on a roll. Park Off Broadway versus New York City Water. 4 and 2. 3. Okay, thank you. Champion Laboratories versus Highline Aftermarket. 8 and 2. I'll give you 5 and 3 and 5. Know that one will continue to ask questions if we believe it's necessary. Okay? So 5 and 3 and 5. Vargas versus Con Ed. That's submitted. Francisco versus Shea. Oh, did I say something? I don't know if I said something. Hemple versus Wise. Oh, Francisco versus Shea is submitted.
Respondent, ready?
Any appellant? You want to submit? I'm sorry? You would like to argue. How much time? 5 minutes? I'll give you 3. Be arguing against yourself. That's not a good thing. People versus Daniel Thomas.
Your Honor, it appears my adversary isn't here, but may I have 6 minutes for argument?
Oh, you don't want to default them? Oh. I'm only kidding. Okay, so what do you want, 6 minutes? You represent the appellant. You don't want rebuttal time?
Against myself, Your Honor? Thank you.
Well, I think he's going to be showing up. That's the thing. That's why I say that. So why don't I give you 5 and 3 and 5 when he gets in, and then if we need further questions, it will be going on, okay? So we got 5 and 3 and 5, okay? Aras versus Vessione.
The plaintiff appellant requests 5 and 2.
5 and 2. 4. 5 and 2 and 4, thank you. Valdus versus 11 East 73rd Street. As submitted. Oh, there you go, sorry. 4 minutes. Hold on a second. 4 minutes for a respondent. Got it. Number 14, Santola versus the City of New York.
Ready for the court, for the appellant, 7 and 3. For respondent, 3 minutes, Your Honor.
I'll give you 5 and 3 and 3. Okay, if we have to go further, we'll continue the arguments. Rosado versus Haldera. That's submitted. And Camacho versus G&R Garage, that is submitted. First case up is, Allen versus Thompson. Give me 1 second, counsel. I'll mop up my mess here. Okay, I got it. Okay, here we go.
Yes. Good afternoon, Your Honors. Thank you for this opportunity to be heard. May it please the court, my name is Christopher Thompson. I'm an attorney and defendant appellant in this action, which asserts claims for legal malpractice on an unfounded allegation that in 2012, I advised the plaintiff respondent, Anu Allen, a friend, to sign a settlement and release agreement with a former employer without having explained the one-word change to that agreement, a change she made after speaking to me. I know the court has our respective briefs and a record of appeal.
So,
I'd
Counsel,
like to
you're saying
focus-
that change, which included and versus excluded, you're saying that your client made that change, that you didn't make that change?
That's correct, Your Honor.
That's not what the plaintiff claims.
In the complaint that is stated in the exhibit that is attached to my motion, she had signed an affidavit in the federal action stating that she had made that change.
But in that affidavit, she says was signed, you prepared it for her, and she signed that affidavit because basically you told her to sign it.
The one-page declaration I did prepare and she signed, but she was stating the truth, that she had made the change.
Well, wouldn't that be an issue? I mean, you're saying one thing, she's saying another? Wouldn't that be an issue of fact?
Yes, it would be, but I think that the real issue before the court is the statute of limitations and the fact that there was no contract. I was representing Ms. Allen, who was a friend of mine. She came to me with this issue, and I tried to help her. There's no retainer agreement. There was no payment. Okay, there's no consideration. All of the things that, and I think it plays out. But what happened here, two things happened. Judge Kelly had the case first when I made my motion to dismiss, and he only opined on part of it with respect to the service. There were 4 points still needed to be resolved, and so when nothing happened, I made a motion to renew and re-argue, anticipating statutorily that it would go back to Judge Kelly, and it didn't. It went to Judge Krausman. To Judge Kraus, Sabrina Kraus, and she then said, well, that motion's moot, and I'll just decide whether there's a contract, et cetera.
So she decided the motion, basically.
She went back and decided the motion that should have been referred back to Judge Kelly, in my opinion, and based on
But the
statute.
thing is, he only dealt with he sent it out for a traverse hearing. I think he had the traverse hearing, and after the traverse hearing, he found that there was good service. So he wanted to deal with that. He never dealt with the other grounds. He never even touched those.
Well-
So Judge Krause was deciding those grounds for the first time. It wasn't like she was reviewing something that Judge Kelly did. She was just deciding the other grounds upon which your motion to dismiss was made.
But that's not accurate, Judge, because what happened was Judge Kelly did discuss the other issues and did question the plaintiff whether or not they anticipated filing an affidavit to show that there was this continuing representation of her. And that all happened, but then the judge...
That all happened when?
It happened with Judge Kelly in a conference, and then he said, I have to decide the issue of jurisdiction first.
Right.
But it was all discussed with him, and quite frankly, when plaintiff said, oh, we'll just file an affidavit, and never did, everything that plaintiff relies on is based upon an unverified complaint. The plaintiff has never stated or supported any of the allegations in the complaint. She didn't verify the complaint. She didn't put in an affidavit at any point thereafter. And this idea of the continuing representation
Counsel,
doctrine
okay.
fails.
So let me stop you. In my mind, I'm listening to the arguments here. Everything flows now from the fact about this settlement agreement, right? This is the source of this dispute here, the settlement agreement.
In 2012.
From 2012, the change in the wording in the settlement agreement. Everything that we're having or arguing about flows from that one thing. You're taking the position is that I didn't do that, my client did it. Your client's taking a position, she didn't do it, you did it. As my colleague was pointing out, we're at the pre-answer dismissal stage, right? So why shouldn't this go before a discovery now where you have the opportunity to actually do EBTs, test her veracity? Because you're saying, look, it's an unverified complaint, so forth and so forth, but she makes that allegation. Unless you can show a video of her signing it or making that change and not me, what do we have here, right?
Everything you said is correct, Judge, except for the statute of limitations. This is a 2012 changed, one word changed to a document. In
So
20
counsel, how do we deal with the fact that I believe you sent the revised settlement agreement to the plaintiff, and there was a back and forth changes with certain language? So what about that?
So that agreement you're referring to, Your Honor, is the 2017 agreement.
Right.
Wherein plaintiff went and spoke to other counsel. And then, as I read the law, broke this chain of continued representation because she no longer trusted me. She no longer believed that I could represent her, so she went elsewhere. And that change was made at the direction of that other counsel. I was able to get her former employer to agree to it. That was signed and completed in May of 2017.
Yeah, but there was a back and forth. You sent the agreement to plaintiff. There was a discussion. She sent it to another friend. That friend sent it back to you. There were discussions back and forth.
And
There's an issue of fact.
100% correct, but completed in May of 2017. A 3-year statute of limitations brings us to May of 2020. Even if Governor Cuomo's extensions applied, that brought us to November 3rd. They brought the action November 20th.
Okay, thank you, counsel.
Thank you, Your Honor.
The appellant's here. Hemple versus Daniel Wise. Are you here? You're here. Where's the appellant? The appellant's still out there. We'll see if he got permission. Yeah. Is he outside? 2 o'clock means 2 o'clock, folks. I'm sorry. Have a seat for a second. I don't need to stand.
Subway. You represent the appellant on Hemple versus Wise? Right. So how much time do you need? You know, counsel, it's 2 o'clock, right? All right, because you're holding everybody else up. All right, how much time do you need? Respondent? All right, forget it. 5 and 3 and 5. Thank you. All right, Counselor, you're back up.
Thank you, Your Honor. Stephen Balkin, Balanced Alt BC for the respondent. May it please the court, we ask this court to affirm the decision of the lower court. I first want to address the last thing that appellant mentioned about how the statute of limitation ended, even if you agree that the continuing representation doctrine and Governor Cuomo's executive order were in effect. He seems to claim that November 3rd would be the date that statute of limitations ended. That's incorrect. This court already decided Murphy versus Harris, and multiple appellate divisions have followed heed, that the statute of limitations was a toll rather than a suspension, meaning the clock stopped in March 20th, 2020. The statute of limitation, if we do the math here, the statute of
Right,
limitation...
it doesn't end on November 3rd. It continues. Whatever time you had left when the toll started is the time you have on the back end on November 3rd, and you had a few more days or whatever to get you within the statute of limitations.
Exactly, Your Honor. And by that math, it would have ended, the statute of limitations would have ended in December of 2020. This action was timely filed in November of 2020, so there's no basis to dismiss this case. And the Supreme Court correctly determined the statute of limitations were not a grounds to dismiss the complaint in this action. Second, I want to address the documentary evidence point raised by appellant. And he didn't call it documentary evidence, but essentially he's arguing that the affidavit submitted by the respondent was documentary evidence, grounds to refute her complaint and grant the motion to dismiss. The affidavit was not documentary evidence. The Supreme Court correctly determined that an affidavit is not the kind of evidence that should be considered on 3211. The case cited by appellants...
It's usually the other way around. When you're opposing a motion to dismiss, that you put in an affidavit to expand or at least expand the allegation and the complaints to demonstrate that you have a cause of action, not the other way around.
Exactly, Your Honor. Yeah. And even if it was admissible, and there's no basis, I mean, even the case cited from the Second Department by appellant in their brief, Fontanata versus Doe, explicitly states that an affidavit is not documentary evidence. But even if it was documentary evidence and should be considered by this, and should have been considered by the Supreme Court, it doesn't utterly refute her claims. It doesn't state, as appellant claimed just now, it doesn't state where, she doesn't admit in it that she made the changes. She just says, I signed the settlement agreement. She doesn't dispute that in her complaint. She alleges that she was given a settlement agreement which was allegedly fraudulently altered unilaterally by her counsel.
Yeah, because she said that she, at least from the record here, that she wanted to make sure she had a discrimination claim, or at least a live claim going forward.
Did, Your Honor, but she didn't want to unilaterally make the change without informing the other party. She didn't even know the change was made. She was just told to sign. She alleges she was told to sign this agreement. It was conveyed to the other side and resulted in fraudulent counterclaims against her.
I mean, so aren't these at least issues of fact that have to survive at least a motion to dismiss at this stage?
Precisely, Your Honor.
Okay. All right, thank you.
Thank you, Your Honor.
All right. Next case up is Freedom Mortgage versus Miller.
Nobody's here.
No, there's someone here.
Oh, I'm sorry, I didn't know that.
Yeah, you're here to respond. You're the only one, right? Right, you wanted 4 minutes. I gave you 4 minutes, right?
Yes, I won't even need half, Your Honor.
Okay. You're the respondent. I don't know how to start the argument.
Good afternoon. If it pleases the court, we're asking the court to affirm the Supreme Court decision. Our position is simple, that the Supreme Court relied on the law as it was written and the prevailing appellate authority at the time of dismissal. There was a facial deficiency with respect to the requisite notice pursuant to RPAPL 1304.
Yeah, because the notice added on some language, right?
It did.
About the debtor creditor law and all that kind of.
Right, so the court
And
ruled.
then the Court of Appeals
I know,
had
the
a
Court of
very
Appeals.
similar case. Now, it sounded like you were trying to argue to us that you didn't agree with the Court of Appeals. And even if we didn't, we're not in the business of reversing the Court of
I understand
Appeals. It doesn't kind of work
that the
that
court
way.
is constrained by stare decisis, and if I had a viable argument to advance for the exemption of stare decisis in this position under these circumstances, I promise you I would have argued it.
I don't know about going out on a limb and telling the Court of Appeals they're wrong. I don't know.
I know, and I tried to do it. I had to give it a shot.
Oh, yeah.
That's the bottom line. The fact of the matter is that the legislature disagreed with the Court of Appeals with respect to their
Right,
intent.
we
But that hasn't been signed either.
that
I mean,
hasn't
we
been-
know
that
they
hasn't been introduced
disagreed, but,
I know.
maybe there'll be another time, and on your next case,
Yes.
that'll work. But we are aware of that and
I understand.
appreciate your argument. but-
And that is the gravamen of my argument, Your Honor.
Right. Anything else?
No, Your Honor.
Thank you very much.
Thank you very much.
Good luck next time.
Park Off Broadway versus New York City Water.
Oh, these guys were already standing up waiting to come up.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for appellants. This Court should reverse because this proceeding is time barred. It's undisputed that in this case, the petitioner went through a three-step process to challenge.
Let me ask you a question.
Sure.
This whole thing about the meter size, that was put out there, right? It wasn't something brand new that they discovered later. 3/4 inch versus 4 inch. It was already somewhere in the record along the way.
Yes, certainly in
that
the,
there was this meter issue, the size of the meter, right?
well, certainly the DEP, in the initial response by the DEP, perhaps not, but in the second response, they said this was based, we charged you attributed consumption charges based on a 4-inch line.
Right.
And at that point that they're saying that, he had already installed a 3/4 inch meter, so was aware
You say
that
he installed,
the petitioner had installed, that had already happened.
which at that point would have caused, okay, go back to you guys and say there was a mistake, right?
Or
Something.
raise that in your
In the
next-
arguments, right?
Yes, correct.
Okay, so it wasn't as if nobody knew what size this was, and it was only at the 11th hour when the new folks came in to argue this. I think it was the, not Park Off Broadway, but there was another company that came and argued this for them?
Correct.
Part
I
of-
mean, that was the position the petitioner hired a consultant, I believe, that
Right.
prosecutes these and advises. And they after the water board had reached a decision that said unequivocally, this is the final review of the building
The
district.
water group, came in.
Water
after,
board,
right.
and then this other group, it's a little confusing because they're called the water group, but that's the consultant. Then they said, hey, we want to bring a new challenge to the same bill based on this argument about the incorrect.
But wasn't that a significant difference in the size of the meter that they alleged?
Well, there's never been a dispute that there was observed an unmetered 4-inch service line. Now, we don't really know from this record how you get from a 4-inch service line to a 3/4-inch meter. So that part's not before, it's not in the record. I mean, I just don't know how to answer the question.
The thing is, the building was undergoing renovation, right?
Excuse me? No.
Wasn't the build-
Possibly, I'm not sure, Your Honor.
I thought that's what the petitioner.
Is that what
alleged.
petitioner, okay. Then
Question?
I can't dispute it, I don't know that.
Question that I have is, when was your client aggrieved by the board's decision?
I'm sorry, I represent the board, Your Honor.
They're the-
So they were aggrieved when?
They were aggrieved when they got the final, July 31st, 2020, when they received a final determination from the water board saying that you.
And the second letter was what?
The second letter was, there's a 3-part process. You apply, you make your first dispute to the Customer Service Bureau of the DEP, and then if you lose there, you can appeal to the Deputy Commissioner of the DEP, and if you lose there, you can go to the Water Board. So in the Deputy Commissioner's letter to them, in I believe it was October, I don't remember the exact date, I'm sorry, but it was the second letter from the DEP where they said that you were billed on a 4-inch service line.
Well, they're arguing, if I look at my notes here, they're saying that you, in a prior unrelated proceeding, actually went back and considered new evidence about the size of the meter. How do you respond to that?
A couple ways, Your Honor. First, I mean, I think there are some factual differences, but it's also, that would be an argument, I guess, as to saying why that could be their argument on the merits. This is why this particular determination is arbitrary and capricious, because you did it differently in a preceding one. I don't concede that point, but it's irrelevant to the statute of limitations argument, because finality doesn't depend on the reasonableness of a determination.
Okay, thank you.
May it please the court. My name is David Roble of the firm Roble Markham, attorneys for petitioner, respondent, Park Off Broadway LLC.
So the strongest argument, I think I'm looking at my notes, is your argument that they did it once before, they should do it again, right?
Yes.
So I looked at that carefully, and I looked at what you quoted, and the quoted says that on this on this administrative thing by Andrew Reitteg, right? Of
Reddick.
DEP.
Reddick, yes.
He wrote down that we agree that since the issue of the meter size was not addressed in the prior administrative decision, we will consider the merits of your current dispute. That's not the same kind of fact
It's
that we
very
have
much
here.
the same kind of
Why?
argument.
How?
And just, if we have to get into the details on this, there's the pipe and there's the meter size, and they're not identical.
Right.
And the city has never denied that the proper meter size is 3/4, and therefore the proper penalty should be 3/4. Instead 10 times more, because we have a 4-inch meter of a pipe that's never used. Now, so this case starts and ends as a simple dispute about a water bill, a citizen trying to get the correct water bill. We shouldn't be this far along just to get the number straight. They heard the first customer. If you actually look at the record, they have a 3-part process.
Well, they put it as a theft of service claim, right?
That's what it is. That's what it's that was surprised the citizen when he was told he had stolen anything, because he didn't steal anything. He simply didn't have a meter for a period of time. And when you don't have a meter for a time, and this is what he did not understand, and this is what explained to him, and which we don't deny, you must pay attributable charges, but they're based on the meter size.
Correct.
The correct meter size is 3/4.
I want to go back. So January 2020, your client had appealed the DEP's decision. And then March 27, 2020, DEP responded and set forth the meter size at that time, the 4-inch. So my question to you is, in May 2020, when you appealed to the board, did you, at that time, since you knew the size, did you make any challenge regarding the size? That's a yes or no.
Yeah, whether
did?
Moshe Fruchter did, he did not.
Okay, no. So the only dispute that you raised throughout has been the charges. Is that correct? I mean, listen, you either dispute the size or the charges or both. And the way I read it, your client all throughout, it's only been the charges.
There is no rule that says
No.
that when
Forget the
we
rule.
file, when someone
No,
files
what
a
you
complaint
did.
about their
No.
bill,
What you did. You either dispute the charge. To me, this is so simple.
Yes.
The charge, the size, or both. So we already know that in 2020, no dispute.
No, I believe that after the fact, the water board, after ignoring our claim, has come to the argument that you cannot challenge the claim anymore. They should have listened to us. They got the right answer. They put us through another 3-step process, which is what we appealed. It's the second 3-step process. It was not a motion for reconsideration. They don't have motions for reconsiderations. We are challenging the second 2-step process. And my client was shafted. It's just a question of how much is owed on the bill. And we're entitled to that. And Article 78 proceedings should have some teeth to them.
That's one more question.
There should be
So
consequence.
in the various appeals, because I have the papers here, any words here that says the size? Because I don't see it.
I don't think I believe the issue was raised in 2 steps. The first step was, are we liable? The second step is, what's the penalty? We're just challenging the penalty. And all claims may be brought within 4 years of the bill. That is the only rule that exists here. That is a shield that the Water Department is now using as a sword. They're saying, oh, we considered everything that happened in the last 4 years. They didn't bring it. And in the reply brief at page 6, they say that it's illogical that they should address an issue that was not raised by my client.
Okay, thank you.
Your Honors, I just wanted to pick up and note that what my adversary is calling the second 3-step process was they wanted to be, and there were 3 responses to that. They said, no, we're sorry, we've issued a final determination, we're not going to look at this again. No, we're sorry, we've issued a final determination, we're not going to look at this again. No, we're sorry, we've issued a final determination, we're not going to look at this again. So in that situation, it doesn't revive or renew the statute of limitations under this court's precedent in Elgahar.
Right, thank you.
Thank you.
Champion Laboratories versus Highline.
Good afternoon, Your Honors. Martin Gagan from Winston & Strawn on behalf of the appellants, the Highline parties. Your Honors, this appeal concerns 2 categories of damages claimed by the Highline parties in their complaint. 1, lost profits, and 2, additional costs incurred due to Champ Labs' breach of the party supply contracts for automotive filters. Now, Your Honors, in a 2-page opinion, and without any oral argument, without any discovery whatsoever, the trial court dismissed both of these categories of damages on the ground that both were barred by the ban against consequential damages in Section 7G of the party's amended supply agreement. In doing so, Your Honor, the court eliminated, in one fell swoop, over $10 million in Highline's asserted damages in this case. Respectfully, Your Honors, that decision was incorrect for several reasons. Number 1, and here's the biggest issue, the trial court simply jumped the gun. As a threshold matter, Your Honors, a ban on consequential damages is only relevant and is only applicable if, in fact, you're dealing with consequential damages to begin with. And on that...
Your argument, at least in part, is that this case is much more like the Biotronic case, where there was found to be like an issue that had to be determined by a jury. That the scenario was a little bit more similar, correct?
Spot on, Justice Kaepernick. That's exactly right. And Justice Schechter respectfully got it wrong with respect to the interpretation of Biotronic. If you actually take a look at that decision and compare it to our case here, there's several things that are directly parallel. First, in both cases, you were dealing with an exclusive supply and requirements agreement, a key point in the Biotronics decision, which, by the way, I'll mention, was on a fully developed record after the close of discovery. Secondly, if you actually look at the product agreement in this case, the parties specifically described the relationship as a quote-unquote partnership, again, similar to the joint venture
Yeah,
in
they
both
used a
Biotronic
joint venture.
and American List. Third, there's actually a whole section in Exhibit 1A to the amended supply agreement that specifically deals with the close relationship between the parties. And then similarly, there's a volume rebate program, also similar to what was at place at Biotronic, in which both parties were equally incentivized to have high profits downstream. So you had that type
I mean, that was kind of like the whole point of this agreement, right?
The idea
So it's
is-
hard to call it consequential, or at least at this stage, until we see what happened, because, I mean, what else was this agreement all about?
Your Honor, again, directly on point. Here's the problem with all this. Yes, as Champ Labs has pointed out, there are cases dismissing, as a matter of law, consequential damages.
Right.
All the points I just articulated is why this case is different. But here's the real nub of this case here. Justice Schechter ordered a special round of early summary judgment briefing just for this part. We're conducting discovery now, right now, and we're going to have more summary judgment. There was no reason to do that. This is $10 million of our claim here, and there are factual issues. And just very quickly, in terms of the contract, 3 quick points I want to make on that. Number one, Section 7G does not specifically define consequential damages, a point, again, the Biotronics court made. Number two, the consequential damages provision here does not explicitly exclude lost profits, which many provisions do, particularly the cases cited by Champ Labs. And third, another point, if you actually read the contracts carefully here, you have this wholesale prohibition on consequential damages and incidental damages in Section 7G. But then conversely, if you take a look at Exhibit 1A to the amended supply agreement here, that allows Highline to obtain incidental damages in the event of a chronic shortage. That you have a consistency. And again, all of these things, I've just listed about a half a dozen reasons why you would need discovery. And the takeaway.
Was there some discussion about the chronic shortages? Because, it didn't seem to be focused upon, but this did, at least part of it, occur during the pandemic, when we know there was a lot of supply line issues.
Again, correct. The real nub of this case is an invocation, our view, Highline Party's view, an improper invocation of force majeure to stop selling these automotive filters down to Highline. Our position is that that invocation was pretextual as a factual dispute. But in terms of this inconsistency, that's a perfect example of why you need discovery in terms of the intent of the parties here. Now, just very quickly, I know my time is short, in terms of, you mentioned Biotronic, in terms of how Justice Schechter respectfully got it wrong here. Now, she noted, and Champ Labs was very quick to champion the point, that here this was reliant upon third-party contracts downstream. That's true. That's correct. However, neither Justice Schechter nor Champ Labs in their brief cited the very next sentence of the Biotronic decision at 808 of its opinion. Quote, "This distinction does not mean that lost resale profits can never be general damages simply because they involve a third-party transaction here." So again, that is not dispositive. And just very quickly here, in terms of the damages, again, the supply agreement between the Highline parties, the argument was it lacked the exact pricing formula at issue of Biotronic. Again, if you read Biotronic carefully, the beginning of the opinion at page 805, the Biotronic Court of Appeals specifically instructed courts not to take this mechanistic, uniform, bright line formula, but rather this threshold issue that we're talking about here is a case-by-case decision that requires a fully developed record. Thank you.
Thank you, counsel. You have rebuttal time.
Good afternoon, Ryan Rackhauer from Quinn Emanuel on behalf of Respondent Champion Laboratories. We asked the court to affirm the Supreme Court's decision below.
So how do you get by what happened in Biotronic, and how do you think that this is so different that we shouldn't at least explore the record some more before the court issues a decision?
Yeah, so Biotronics instructs New York trial courts who are trying to determine whether lost profits constitute general damages or consequential damages to look at whether the non-breaching party bargained for such profits and whether they're direct and immediate fruits of the contract. And importantly, Biotronics emphasizes that the distinction is whether the lost profits flowed directly from the contract itself or were instead the result of a separate agreement from a non-party, which I think the other side just admitted, these are all the result of separate agreements with non-parties. Now, in concluding that lost profits constituted general damages in the context of that case, the Biotronic court focused on the fact that the agreement there was, quote, not a simple resale contract where one party buys a product at a set price to sell at whatever the market may bear. And that's at page 803 of the opinion. Now, the agreement at issue here is just that. It's a straightforward supply agreement.
It's not a joint venture?
I'm sorry, what was
it? Not a joint venture?
It's not a joint venture, Your Honor. Here, under the supply agreement, Champ Labs supplies Highline with aftermarket automotive filters. Highline pays Champ Labs fixed prices for those filters, and Highline can then do whatever it wants with the filters.
Yeah, it's the middleman. It's sort of the middleman, so to speak, right?
Well, the distinction I would draw between it being a middleman is that Highline doesn't have to resell the filters. It can choose to, but it doesn't have to. And
What are they going to do with them? I'm sorry.
I adopt.
Sorry, don't chicken.
Someone asked a question.
So it's not, what else? The contract doesn't require them to do anything.
They're not buying 6 million plus products to just sit and look at them on their shelves, are there? I mean, nobody does business like that.
Well, the contract permits Biotronic to do just that, if they want to. And I do want to bring up, because the other side brought up the rebate provision. And the rebate provision is actually not dependent on how much or how little Highline resells. That provision simply, again, gives a volume rebate based on how much Highline orders from Champ Labs. It's irrelevant to whether or not Highline receives the rebate, how much Highline resells after. Champ Labs compensation, unlike in Biotronic, Champ Labs compensation under the supply agreement is not at all dependent on how much or how little Biotronics resells.
What was the essence of the supply agreement and the related subsequent agreements? What was the essence of it?
The essence, Your Honor, is Champ Labs' sale of filters to Highline. The essence is not Highline's resales. In fact, there's no provision in the supply agreement, and this is another distinction from the Biotronic case. There's no provision in the supply agreement that requires Highline to take commercially reasonable efforts to promote, market, distribute, resell the filters. Again, Highline can do what it wants. That's not the subject of this agreement. This agreement is purely about Champ Labs' sale of filters to Highline.
Well, I don't understand, why would Highline enter into an agreement if that's the whole point of it, is that they buy lots of stuff? I mean, obviously that's their business, and they are, what were they called? A midstream supplier. I mean, obviously obviously the whole point was to buy it from the manufacturer, and then they distribute it to all the other people, and they had an exclusive, they had to get it from you. So if they couldn't get it from you, then their whole business was just sitting there with millions and millions of dollars of product.
So
I don't see how that's not like the essence of the agreement.
The agreement has no provisions other than authorizing Highline to resell if it chooses to. The agreement doesn't contain provisions that require Highline to resell or put restrictions on Highline's resale. So I would disagree with the point that the essence of the agreement has to do with resales. It's all about the sales by Champ Labs to Highline. And one more point I just want to raise is the chronic shortage provision, which I think makes even more clear that the parties didn't intend to permit lost profits as damages. Now, we disagree that that provision applies. We believe that Champ Labs properly invoked force majeure. That's a fight for another day, because if you're going to assume that there was a breach of contract for failure to supply requirements products, that's the provision that would apply. And that provision provides that Champ Labs would promptly reimburse Highline for its cost of cover and associated incidental costs with that cost of cover, not lost profits. So I see that I'm out of time. Thank you. We ask the court to affirm. Thank you.
Thank you.
Sir, is there anything in the supply agreement or the related subsequent agreements that suggests that the parties contemplated that your client would resell the Champion product?
Here's the quick and direct answer, Your Honor. Yes. And how do we know that? The very first sentence of the amended supply agreement. If you take a look at Section 1A, it specifically provides that Highline would resell the automotive filters to various third parties. And this is exactly spot on to the Biotronics' first point at page 805 of its opinion. The court asked, in this scenario, what are courts to do? They are to look at the very essence of the contract. And if the quote-unquote the essence of the contract is to resell, then this is why you need a developed record in terms of whether lost profits were properly recoverable. So to the point here that somehow this, as a mid-seller of automotive filters, that the entire point of this entire transaction is not to sell it downstream, that's just an academic argument that's divorced from any kind of reality and is divorced not only from the contract, but from also from the holding in Biotronic. Now, just very quickly, moving on, again, we have sort of this hyper-technical argument that, no, Your Honors, the pricing formula in Biotronic, that's different. And you have these sort of like these various permutations. That's why that's not applicable here. It doesn't matter that there's differences. Clearly, the entire point of this entire transaction was to resell downstream. And just on the rebate point, point 3 here, again, in terms of how this worked, and just so it's clear here, under the volume rebate provision, the more filters that the Highline parties ordered, the cheaper they were. These rebates were calculated on a quarterly basis, and Your Honors, they were fairly substantial. The Highline parties could be afforded $600,000 per quarter or $2.4 million per year. So what's the point of all this? This heavily incentivized the Highline parties to create a strong, durable market downstream for everyone, for Champ Labs products, and that would result in greater profits for both the Highline parties and for Champ Labs.
So, counsel, so the resale volume was determined by, I guess, the per product price from Champ Labs, and that was like based on credits and rebates?
Yeah, that's exactly right. Under the volume rebate provision, the more filters that Highline parties ordered, the cheaper they were. And I see my time is short here, but just very quickly, I did want to address the other issue on appeal here in terms of these other costs, and I'll say the same point here. Just very quickly, there are 8 different categories of damages here. Just the same with Justice Schechter's one fell swoop, one size fits all, which is exactly contrary to the instruction and directive of the Biotronic court here. What we got here for these 8 categories of documents, not only no discovery, not only no argument, we got one sentence. Okay, with all due respect to Justice Schechter, this is over $500,000. Our case was gutted here with no discovery, no oral argument, and no thorough analysis.
You're basically saying, if I'm hearing correctly, is you guys went into this deal knowing it's all about profits, right? I mean, that's it. You wanted to make money, right?
Of course, Your Honor.
This is not consequential damage. It's not excluded because we don't say it, because we went into it for this full purpose of making sure everyone downstream, we're going to have a lot of money here.
Yes, Your Honor, I reject respectfully this academic approach taken by my colleague here. The whole point of this was obviously for both parties to make monies, and I'll end where I began. With respect to a prohibition on consequential damages, it only matters if it's consequential damages to begin with. And that threshold determination, it should not have been made as a matter of law here. It should have been made after discovery upon a complete record. I thank the court for its time.
Thank you very much. Thank you. Hemple versus Wise.
Good afternoon. May it please the court. The firm brings this appeal on behalf of the defendants, appellants in this case, on 3 grounds. The first ground is that the lower court respectfully, improperly dismissed the first counterclaim for breach of contract. All 4 elements for breach of contract were pled in the counterclaim. The allegations followed the notice pleading requirements under New York state law. And the court misapplied a heightened pleading standard to this breach of contract claim. With regard to the second...
my notes indicate that in terms of the court below granted summary judgment to the plaintiffs, right, on their promissory notes and guarantees.
Yes.
So your argument below was that the sharing agreement modified the terms of the notes. Because the sharing
Yes.
agreement said something, amended sharing agreement says something along the lines that whatever money or profits that your client makes will be used to retire any debt that's outstanding. How does that alter the notes, the promissory notes, as well as the guarantees, which were all amended to now have October 1st, 2019 as the new due date?
There are three critical dates that affect the maturity, the ultimate maturity of the notes. The first note was made back in April of 2014. That was a first loan for $300,000. Then there was a second subsequent note. Ultimately, there was a sharing agreement in November of 2017. In January of 2018, the parties worked out a project schedule for the construction. It was a 10-month schedule from July 2018 through April of 2018. At that time, they subsequently made a modification or an amendment to the sharing agreement, pushing forward all the dates past the anticipated completion date. And there is a phrase in the amendment to the sharing agreement, is that R59 at page 1, which states that the payments...
Any money that your clients owed, that your client's entitled to receive, if there's an outstanding debt, it will be going to pay the debt, right? That's what you're looking at.
And the critical three words here are regardless of whether then payable. So at the very least, I would argue that the maturity dates in conjunction with the sharing agreement and the amendment, it's ambiguous.
How do you get around? Yeah, but how do you get around? That's talking about other documents. You're trying to use that document and sort of bootstrap that to the promissory notes and the guarantees, which by their own terms say they can only be amended in writing, right? There's no modification, and there's, I mean, just by the sharing agreement saying in terms of how the profits are going to be if there are any profits, I don't understand how you link the two, that profit sharing versus how much you owe on the debt.
I believe the parties linked the two within that same paragraph, that 2D, in the amendment to the sharing agreement on page 59. Again, this is a long, winding business relationship that the parties had involving multiple properties, multiple agreements, and when they come to this amendment to the sharing agreement, they recognize that they have these notes that were made over time, and they anticipating that the project for $330,000 will be completed in April of 2018.
I don't see, I mean, unless I missed something, I don't see anything in the amended sharing agreement or the sharing agreement that actually pointedly says that the notes and guarantees are hereby incorporated herein. I mean, you're making the argument that that's what the party's intent was in terms of when they did the sharing agreement and amended sharing agreement, right?
I agree that the agreement was not the most artfully written agreement.
You think? That's why we're all here.
Well, sometimes we litigate also written agreements. I think one issue with some of the ambiguities in the sharing agreement and the amendment and how it referred to the notes is that the same law firm was representing both parties in this agreement. And there's a waiver on the last page. And I think that does come into play. Both parties had representation by the same law firm where, again, I think that law firm was trying to appease both parties. They put together this agreement, and it creates the ambiguity here. I would think at the very least our client should have the opportunity to conduct discovery with regard to this claim on the summary judgment motion, similar to the two counterclaims that were pled.
But there's no ambiguity in any of the notes or in the guarantees as to when the notes matured and as to the notes being guaranteed by the other three entities.
Correct. If we had a situation where we only would have the notes, then I wouldn't have an argument. It's the fact that the parties here in 2D, they specify all three notes, and they specify the maturity dates, and they create this language here that it's going to be payable regardless of whether then payable. And again, it's linked to the project that both of these parties are working on at $330,000 at this point for 2 or 3 years. That's the issue here, is this paragraph in 2D. It links all three of the notes that are part of plaintiff's claims.
Okay, thank you. You have rebuttal time.
Thank you, Your Honors. Damian Albergo on behalf of the respondents. There is no ambiguity in the notes and the guarantees.
You know, I mean, I think that it really pretty much comes down to that paragraph that your colleague was referring to, paragraph 2D in the amended sharing agreement on page 59, which does make reference to each one of the loans specifically and for the amount, and potentially muddies the waters by its language. So can you address how this would not at all affect, because we know that, you know, with promissory notes, if there's anything out there that could affect it, then we don't want to grant summary judgment on it. So how does this paragraph
Sure, Your Honor.
sort of muddy it up enough to prevent summary judgment?
Doesn't muddy it at all in respect of referring to the maturity dates whatsoever.
Well, the maturity dates, no, I think the maturity dates are good, but the thing is, do we still have to be concerned about this?
No. The only thing that paragraph 2D says is that if Mr. Wise is entitled to any compensation under this agreement, it goes to pay the loans first, and that he's not entitled to anything until the loans are paid in full. That's all this says. And I want to point out that below, this argument that makes the loans payable only from the profits, if there ever is one, and that it extended the maturity date is really just an invention of counsel. In Mr. Wise's own affidavit that he submitted below, in paragraphs 47 to 52, he doesn't even say that what was the intent of the parties. He just...
somewhere I read, and I'm not sure where it is right now, that they weren't even sure there was going to be a profit.
That's right, because how can you condition payment of a note that's absolute and unconditional and says it's not, payment is not to be withheld
say
for
that
any
it's
defense
conditional
or counterclaim? And even Mr. Wise said in his affidavit they were hoping that they were going to make money. That's why they extended the dates out. But the lower court was correct. This doesn't delete the maturity date. And the lawyer, Mr. Goldberg from Meister Seelig, who drafted this contract really as the scrivener for both parties, and he says in the sharing agreement, I'm not acting as counsel for anybody. Everybody get their own counsel. The emails from Mr. Goldberg, which are attached to the record, says the purpose of this agreement is to make sure the lender gets paid before Mr. Wise sees a nickel. There is nothing that changes the absolute and unconditional obligation to pay in the notes and the guarantees. They're trying to treat a maturity date of October 1st, 2019 as an illusory deadline. The notes, amendments, and the note that was note 3 and the sharing agreement were all drafted at the same time by the same lawyer. If the intent was to not have a maturity date, there'd be no reason for default interest, there'd be no reason for a maturity date, and what lender would loan money with no date for repayment premised upon hypothetical profits? Separately, my argument is on the counterclaims, the court doesn't have jurisdiction because their notice of appeal is limited to the summary judgment. I know that they refer to the informational statement, but the informational statement is not part of the record. We found no case anywhere in the state that makes the informational statement relevant or it's an amendment to a notice of appeal. And the plain language of the notice of appeal is only limited to the summary judgment. We cited the Vandergram Properties case, the Handelman case, the Martin Silver case that says when the notice of appeal is limited to only part of an order, the First Department has no jurisdiction to entertain any arguments not listed in the notice. The counterclaim for breach of contract was properly dismissed because what was alleged that Ms. Cheryl Hemple did wasn't a breach of any terms of the agreement. The court had the agreement submitted to them by both parties, compared the obligations or the alleged rights and obligations and breaches by Ms. Hemple against the language of the sharing agreement and said there is no link between the allegations and the agreement. And the fiduciary duty claim, the sharing agreement in paragraph 5 says the parties are not partners. And in addition, Mr. Wise, his own admission and allegations said that sole and exclusive management in the project was vested in Ms. Hemple, and you need joint control and management for there to be a partnership. So there was no fiduciary duty. Plus, Mr. Wise changed his story on the motion below, and in his affidavit no longer said that he was the partner. He said his company JTD, which was the construction manager pursuant to a construction management agreement, was the partner. So even Mr. Wise couldn't get his own story straight as to who was the partner. So the court properly granted the motion in all respects. We ask that the order be affirmed in its entirety. And unless you have any other questions, I see my time is up.
Thank you, Counselor.
Thank you.
If I may just respond on 2 points. The first point is with regard to the intent of the parties on the notes and the sharing agreement. In Mr. Wise's affidavit, this is record page 140, he references the project schedule where it would go from July 1st, 2018 to July 1st, 2019. The next paragraph, he states that the parties then modified their prior personal loans under 1 and 2 and entered into a new loan 3. It would be extended to October 1, 2019, in line with the project schedule to approximately 3 months after scheduled completion of the 330 grant project. Again, this is not a situation where you have promissory notes in a vacuum alone. These promissory notes were entered into over time as the parties were also engaged in the development of this project at 330 grand. And they were referenced in that important paragraph that I alluded to before. If I may, just on the issue of jurisdiction, the information statement is part of the record. It's attached in the underlying case. It's a NICEF number 50. In this case before the court, it's NICEF number 1. The case that was cited to by my colleague, I looked up that case. The information statement did not have the full reference to all of the claims. And here we definitively do. The information statement goes into detail with regard to the counterclaims as well as the summary judgment motion.
Okay, thank you, Counselor.
Thank you.
People versus Daniel Thomas. Just so you know, I gave you 5 minutes. All right. Okay.
Good afternoon, Your Honors. My name is John M. Baselli. I'm appearing on behalf of Appellant Mr. Daniel Thomas. Mr. Thomas deserves a new trial because when the lower court refused to submit the petit larceny of the complainant's wallet to the jury as a lesser included offense, it did so on a basis that this court and its sister appellate division in the 3rd Department had already rejected, and notably, the prosecution has not addressed these cases. Under those 3 cases, Desnoyer, Brewer, and the 3rd Department's McGee, which are centerpieces of our briefs, where there's evidence that a defendant stole a wallet, but there's a reasonable view of the evidence, it may not have contained any one particular...
Counsel, I have to ask you a question. All right. We have here that was the charges submitted to the jury were based for 6 credit cards, I believe, right?
That's right, Your Honor.
So that all you need is 1 credit card to avoid or to not get the lesser included charge.
I would disagree, Your Honor. I would flip it. I would say all Mr. Thomas would need to prove is that there's a reasonable view as to any particular 1 count, and that would be sufficient to submit the lesser of the wallet.
Wait a minute. When you say that all he has to demonstrate is that there's a reasonable view that there will be 1 count that he could be convicted?
So if I may...
Because if you find that there's a credit card, right, all boils down to a credit card, right? I mean, if there is a credit card there, you don't get the lesser included charge, right?
Well, the jury would have to credit the complainant's testimony that the credit cards were in the wallet. And here, there's a reasonable view of the evidence that, given her messy and shifting narratives over time, the jury had a rational basis to say, we're not going to hang our hat on her testimony, but there's a surveillance video and evidence showing Mr. Thomas allegedly stealing a wallet, and the jury had no mechanism to convict him of the crime they saw him commit.
So let me ask you this question. Then why is it then, and I'm looking in your briefs here, that you're not challenging the sufficiency of the evidence of five, you're only challenging the sufficiency of the evidence of the credit card 1. That's the credit card. The other 5 credit cards that were present to the jury are not based on, you're not challenging the sufficiency of the evidence there? How does that affect this whole analysis then?
I don't think it does, Your Honor. Counsel below didn't preserve a sufficiency claim, but through a weight analysis which necessarily incorporates an elements-based analysis per the Court of Appeals in Danielson. That's our
But I would think that you would be challenging all the credit cards that were being put forth in the jury as being against the weight of the evidence. Forget about this.
We did, Your Honor. All 5 were challenged as against the weight of the evidence. There was a particular sufficiency challenge on the credit 1 credit card, however, notwithstanding it not being preserved. But all 3, I should say, that Mr. Thomas was convicted of, the grand larceny of, and the criminal possession of stolen property of, were attacked as against the weight of the evidence in our briefs. I apologize if that wasn't clear, Your Honor.
Are you saying that the fact that petty larceny was not charged as a lesser included offense basically vitiates the entire conviction of this defendant?
Well, I think
on all charges.
Well, I think, Your Honor, given that because counsel demonstrated there was a reasonable view of the evidence sufficient to support the lesser, the criminal procedure law refers to that as a sort of plain error. The case had to be sent back. But I think, Your Honor, if I may expand on what I think you're getting at, without the lesser included here, there was a real fear of a compromise verdict because there were problems with the complainant's testimony. The jury acquitted on half the counts. They sent 3 notes demanding extrinsic corroboration. Where are the credit card statements that back up what she says? Where are the cancellations that she's talking about? And because of the doubts about the complainant's testimony and the jury having no option to convict him of the crime they saw, the lesser included here would have been a bulwark against a compromise verdict. And if I can briefly...
What would the remedy be? Send it back for a retrial?
That's right, Your Honor, and reversal of the convictions pending the outcome of that retrial. And if I can briefly turn to my authentication point, which I would also argue requires a reversal and a new trial, here the people's most vital evidence, that security video, which would have supported the lesser, it was admitted in the form of a pre-extracted snippet, and it was not authenticated as a genuine reproduction of the master footage because the witness authenticating it had never seen that raw footage. She wasn't empowered to access it at her job site. She was never asked, once that footage was extracted by her senior officer and saved to another computer, if it couldn't be altered on the content level. There was no proof of security measures on that other computer, that the extracts were password protected, something to prevent public access. Their bottom line is this record is devoid of testimony, establishing those extracts, which were indispensable to the prosecution here, as genuine, without tampering, and identical to the servers from which they were taken. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Stacey Nadell for the people. As to the lesser included offense, Your Honors, it was not error for the Court to not charge this and for the jury not to consider it.
Wasn't there a reasonable view of the evidence that he took the wallet and that was a petty larceny?
Your Honor,
That's what the video showed. It showed him taking the wallet.
Correct. The video shows the defendant took the wallet from the victim's purse. However, there's no reasonable view of the evidence to suggest that the credit cards were not in the wallet. We know from the victim's testimony that she needed to access the inside of her wallet when she arrived at the Riverside Health Center in order to give the proper identification and payment card for the class. She had to register and pay on that day. So she testified she had looked in her wallet that morning. She knew what was in it. And she was able to describe on direct examination and cross-examination the contents of her wallet, which included various credit and debit cards and her...
But that's an issue for the jury to weigh the credibility of the complainant. Whereas by viewing the video in and of itself, they can say, well, he committed a petty larceny.
That's correct, but when you take the evidence as a whole with the video and the jury was able to see and assess the witnesses and determine whether they were credible or not based on what they were saying, when you take the evidence as a whole...
Well, they didn't credit everything she said because they acquitted on a number of counts.
That's true, but that just goes to show that the jury was very careful in assessing the proof.
But shouldn't they have been provided with the opportunity to also assess whether or not he was only guilty of the larceny?
Even if that was the case, if they did not find that there were credit cards in that wallet, the defendant was entitled to an acquittal, which is...
Because the indictment only really made reference to the credit cards. It never mentioned the wallet, right?
Correct. The wallet was never charged.
The jury saw this video, right? The jury saw the video?
Yes.
Does the video depict the defendant opening the wallet?
It does not.
It does not.
But when you take the video in conjunction with the testimony of the complaining witness and the security officer who spoke with the complaining witness immediately following these events, when you take all of that together, the reasonable view of the evidence is that there were credit cards in the wallet.
You're saying that even so, as your friend was saying, that the victim's testimony was sort of waffling back and forth, the response to that, the jury obviously acquitted him on some counts, but didn't acquit him on the other counts. Taking into consideration the sort of, her testimony going back and forth on direct and cross about what was in the wallet.
The complaining witness wasn't really going back and forth.
She wasn't sure about certain cards, maybe misnamed them. There were different times, it seemed to me from what I read, from what she told the security guard initially to what she ultimately testified to, as to what she told people, that she wasn't sure exactly what was in her wallet. She was a little unclear.
So while the testimony is not as clear as we would like, on direct examination, 2, 4, 5, 6 credit cards came out, and the same thing with cross with the addition of an additional card. So when viewing that, and the complaining witness was providing the names of the credit cards and the types in response to questions by the people and the prosecutor, in addition to a little bit of narrative on her direct examination. When looking at that, based on the questions and probing, her direct and cross provide a full story of what was in her wallet.
I guess it depends on whether or not there was a reasonable view in light favorable to the defendant. Is that's what we have. There's sufficient evidence here that would allow you to say there was a credit card, right? I mean, that's basically the argument, so as to preclude the lesser included charge.
Yeah.
What is the one evidence that we know for sure is what the video shows him taking the wallet? That's the one thing that everybody that sees that video can agree on. He took the wallet.
Yes.
As to whether or not those credit cards were inside the wallet, now it's an issue of credibility whether or not they believe the complainant that the credit cards were in the wallet. So should the defendant not have been given the opportunity to put before the jury, okay, whether or not they believed the video and didn't believe the complainant and convicted him only of the larceny? Shouldn't that have been something for the jury to have considered?
I see my time is up. May I answer the question?
Yeah, sure.
Even if the petit larceny was charged, when you look at all of the evidence, the jury is in the best position to assess the credibility of those witnesses. True, we have a video, and that's incredibly helpful, but the video doesn't tell the whole story. And if the jury...
It says a lot. It says a lot.
It says a lot, but not the whole story.
Without anything else, you can see that he took a wallet.
Yes.
And that's it.
Yes.
That in and of itself says a lot. He took a wallet. Now we have to believe the complainant that inside that wallet there were credit cards.
Yes, and
so the jury should have been able to have an opportunity to decide, do we convict him on taking the wallet, or do we go further and say, inside that wallet there were credit cards, like the complainant said that there were credit cards?
Even if the jury didn't find that there were credit cards or debit cards in the wallet, the acquittal would have worked, and it did, in his favor. He was acquitted of multiple charges.
But they were not given an opportunity to consider whether or not he was guilty only of the petty larceny, because that was not charged. And that's the argument that the defense is making. That should have been before the jury.
Your Honor, there was no reasonable view of the evidence in its entirety to support that conclusion. The charges focused on the credit cards, the grand larceny, and the stolen property. And when assessing the evidence in its entirety, which the jury did, they found that there were credit cards in the wallet. And there's a plethora of evidence we elaborate in our brief to show that, and to show that that basically a reasonable view of the evidence shows that there were credit cards in the wallet.
Thank you.
Thank you.
If I may address questions from Justice Mendez, Justice Kapnick, and Justice Oing. Justice Kapnick, to your question about him not being indicted for the theft of the wallet, implicit to this court's holdings in Desnoyer and Brewer, as well as the third departments in McGee, those were credit card theft prosecutions charged as fourth-degree grand larcenies. And the uncharged theft of the wallet container in those cases, the court accepted the proposition that those could be submitted as a lesser included where it occurred simultaneously with the credit card theft, which is what we have here. The problem in those cases was there was no reasonable view of the evidence. And additionally, the people's trial summation is crystal clear that they viewed the theft of the wallet as an elemental lesser. In summation, the prosecutor said, really, elements 1 and 2 of grand larceny 4 aren't in dispute. The defendant took the wallet, and he took it for his own benefit. So defense is taking issue with the third element, which was whether in the wallet were the 6 credit cards the complainant alleged. That's page 113 of the transcript.
Could the defendant have been lawfully convicted of petty larceny based simply on his theft of the wallet?
Yes, Your Honor, that would be the whole, that would be the gravamen of the petty larceny for the theft of the wallet.
But yet that the theft of the wallet was not addressed in the indictment.
That's right, and that was my response to Justice Kapnick's question, that this court's precedent, as well as the stance the prosecution took in summation, would seem to allow for that to be a lawful result here. As the prosecutor said, Justice Higgett, that's why people steal wallets, because of the contents of them. But Justice Oing, if
Doesn't that cut against your argument then?
I don't think so, Your Honor, because the prosecution made it absolutely, I could not have written it more straightforwardly, that they thought the petty larceny of the wallet was subsumed elementally into the grand larceny counts. But Justice Oing, if I may address your question about the sufficiency of evidence, which, we're in a different posture here because in the reasonable view, lesser included world, we have to draw all inferences in the light most favorable to Mr. Thomas, unlike in legal sufficiency. And here to Justice Mendez, something that I think you've been pointing out here, the complainant's memory about the contents of her wallet was globally impeached. She said, I had 6 credit cards in my wallet. The impartial detective said she only told me 3. The complainant's response, she was wrong. I knew everything in my wallet. This complainant told the grand jury that her driver's license was stolen in the theft. But then also under oath at trial, she says, I lost it a long time before. I wasn't even sure of my grand jury testimony. And that's page 41 and 40.
Sorry, but how does the jury's credibility findings, how do those findings relate to our inquiry here as to whether a reasonable view of the evidence supports the lesser included? Because clearly I wouldn't say clearly, but it would appear as though they made a nuanced credibility findings. They partially acquitted your client. So they must have credited the complainant's testimony, at least in part. How does that factor in at all to us determining whether a reasonable view of the evidence supported the petty larceny?
May I answer your question? Just
add to that?
Sure.
Particularly since it was on cross, actually, that the complainant said that the credit 1 card was also stolen. And Officer Davis indicated that the complainant reported to her that the credit 1 card was stolen. So can we add on to that with Justice Higgett's question?
So Justice Higgett, there is precedent from this court. It's People versus Oliveira. The site is 45 AD 3rd, 154. It's a 2007 case from this court. And there, this court looked to jury outcomes. In particular, there was a hung jury and said that the jury's failure to arrive at a verdict on particular counts was stark proof that reservations about the witness's credibility existed. Now, I would submit, Your Honor, and this I think goes to your question, Justice Kennedy, that the complainant here, her testimony did not have to be globally incredible to warrant submission of the lesser. This court said in Oliveira that when there is a rational basis to doubt a witness's credibility, the jury has the prerogative to completely disregard their testimony. And we have a witness here, as I was saying, who testified inconsistently under oath twice about contents of her wallet.
Okay, counsel, let me ask you this question. As I'm hearing the arguments in my notes here, there was never a point in the testimony, both on direct or cross, where the victim came out and said, I don't remember that there were any credit cards, or there could have been no credit cards in my wallet. I don't recall that actually being testified to. So what happens here is that in terms of taking what you're saying is that the victim here was waffling back and forth in terms of how many credit cards were in the wallet. As my colleague Justice Higgins was pointing out, that's where the jury sort of nuances and says, okay, you know what, you're waffling so much. We know, we didn't hear any testimony that you're saying that there was 0 credit cards, but you're waffling as to how many were in there. So that's how they nuanced their verdict and say on some of the counts they acquitted him on other counts they found him guilty. You understand that question? Like, why is it then you're entitled to a lesser included charge under those circumstances?
Well, I think as a fundamental matter, Justice Owing, any lesser included offense appeal necessarily presupposes a conviction on the greater that's being complained of, right?
Right.
But the Court of Appeals has made it clear that a witness's problematic or imprecise memory, and that's in Scarborough, can be a basis to disregard their testimony. The fact that the jury resolved some of those doubts in favor of conviction doesn't change the fact that counsel made out an adequate showing that there was a rational view to not credit this witness's testimony, which was borne out by the jury's rejection of half of what she said. And I think, Justice Owing, your question would make a fabulous closing argument to the jury here about why about why they shouldn't have
that up a while ago. Thanks.
about why they shouldn't have found Mr. Thomas guilty on only the pettit larceny and acquitted on the grand larceny counts. And that's precisely the problem. The jury could never consider that because the court refused to instruct the jury accordingly.
Thank you very much. Thank you. Arias versus Visione.
Good afternoon, Your Honors. May it please the Court. Kenneth Gorman for the plaintiff appellant. Dismissing the plaintiff's complaint pursuant to CPLR 3216 under these circumstances just wasn't warranted. The plaintiff actively litigated her case, and the defendants can't point to one instance where she didn't. The defendant served after the defendant served the 90-day notices, they served discovery demands, which contributed to the plaintiff's inability to file her note of issue. And since the defendants contributed to the plaintiff's delay, she was not required to show a meritorious defense. A meritorious cause of action. Lee versus Rad, 132, Appellate Division 2nd, 643, 2nd Department. But regardless, with the submission of her expert's affirmed report, she did establish a meritorious cause of action. Dr. Klausner said that Dr. Vecchione departed from accepted dental practice by straying outside the surgical field, which caused him to sever the plaintiff's lingual nerve. And in the event this court reinstates the complaint, we submit that she should be granted leave to amend it because Carlos Luna admitted at his EBT that he was not certified to work as a dental assistant. And physicians may be liable for the neglect or fault of an employee working under their care. Since plaintiff diligently prosecuted this case, and because the parties contributed to her delay or inability to file the note of issue, we respectfully submit that the complaint should be reinstated. Thank you.
Thank you, counsel.
Afternoon, Your Honors. Brennan Breland for Defendant Respondent, American Dental Centers. This court should affirm the judgment and order below because the appellants have not demonstrated any abuse of discretion in the trial court. The trial court fundamentally made 4 decisions, each of which are subject to review on that basis. The first fundamentally is dispositive as to the rest of them. That is the dismissal of the case under or pursuant to plaintiff's failure to comply with the 90-day notice. As the court below noted, there are 4 options that the plaintiff has in response to the 90-day notice. They can file the note of issue, they can move to vacate the note of issue, they can move to extend their time to comply, and then they can move to vacate their default. And that leniency, that broad grant of response capability is what underlies plaintiff's lead case's position. That
They did a cross motion to amend, right, instead?
I'm sorry, Your Honor?
They did a cross motion to amend. Is that what happened?
They did.
Right?
Yes.
Instead of taking any of the four options, they went with an option that you didn't think, well, it was kind of didn't understand why they took the other option, right?
I understand their rationale for taking that option. The fact remains that under the Baskowski line of cases, that's not an option that would obviate or satisfy a CPLR 3216 90-day notice.
Right, because you're confronted with an option, you're confronted with a motion of a 3216. You got the 90-day notice. You're thinking out, okay, the first thing I got to do is try to oppose the 3216, right? And what do I got to do? It's simple in that sense, right?
Yes, Your Honor. That's exactly our point. Sorry, please.
No, go ahead and finish.
That was my argument.
The Court of Appeals has counseled that 3216 is a very forgiving, that may be their exact phrase, procedural statute. Here they did attempt to go down path number 4, right? That is, put in the
to move to
reasonable
vacate their
excuse,
default?
the reasonable excuse, and then an affidavit of merit. And the court credited their reasonable excuse. And so now that leaves us with what was the deficiency in the affidavit of merit. They did have the affidavit or affirmation of Dr. Klausner?
Klausner.
What was the shortcoming or shortcomings in that affidavit or affirmation that defeated that second element of the necessary showing?
First, I would submit that the court below granted, functionally for the sake of argument, that the reasonable excuse and demonstration of merit were even relevant to the inquiry, because as the court noted below, those are issues that arise on a motion to vacate the default, which was not made and has not been made to date. However, assuming arguendo that those inquiries are properly before the court, and assuming that their excuse is reasonable, the deficiencies in Dr. Klausner's affidavit are that Dr. Klausner made conclusory, unsubstantiated, and unsupported allegations as to the liability or malpractice deviations from the standard of care for the malpractice claim, and failures in terms of providing informed consent on the second cause of action. Dr. Klausner's affidavit provides no supporting rationale at all. It provides a very brief statement of what Dr. Klausner believed the facts to be, and then the threadbare assertion that this was inadequate under the standard of care for the malpractice claim and inadequate to provide informed consent. And that was the finding of the trial court as well.
Okay, thank you.
Just briefly, it's a potentially meritorious cause of action, not a meritorious cause of action. And even with that being said, I just want to refer the court to the Second Department's decision, Kozlowski versus Ona, 10280. I'm sorry, I don't have the whole site written down here. I apologize, but it's cited throughout our brief, and it's discussed. And the Second Department held that the plaintiff's expert oral surgeon raised an issue of fact by opining that the defendant, oral surgeon, strayed outside the surgical field, and that caused him to sever the plaintiff's lingual nerve. The same thing could be said here. And Dr. Klausner's opinion is no less than the opinion that the expert gave in Kozlowski. Thank you.
Thank you. Valdus versus 11 East 73rd. Oh, you're both here. I didn't know you were here. Did I not know that? Did you, when I called the calendar, were you here? Or?
At the initial call of
Yeah.
counsel, I was outside, Your Honor, but I did submit one of the notices of appearance at 1:30 this afternoon.
Okay. I thought you were the only one that got up. When I made the call to the calendar, I thought you were the only one that got up.
That's what I thought as well.
Okay, so you didn't notify anybody that you appeared because I didn't grant you argument time. Okay.
Judge, I'm so sorry. I'm so ignorant. I don't even know what I've done wrong here. So
Oh, well, when I called the calendar, you weren't here when I called the calendar.
I'm very sorry, Your Honor.
Okay, that's all because I want to make sure I didn't have a
No, Your
senior
Honor.
moment.
Absolutely not.
All right, you got 5 and 3, and you have 5, okay?
Thank you. And my apologies. If it please the court, my name is Carolyn Rankin.
There we
Represent
go.
the defendant appellant in this action. This is an appeal from the decision of a lower court, which granted the extreme relief of a permanent injunction under situations that, if allowed to stand, would completely upset the status quo of the circumstances and effectively grant the ultimate relief sought by the plaintiff in absence of a demonstrated irreparable harm. This is a case with the two properties or two historic homes that abut one another. And on the east wall of the plaintiff's home is this party wall. Now, we're just going to assume for this argument, back in the 1950s, the courts determined that this was a party wall. Both parties have the right to enjoy it, and both parties have the obligation to maintain it. The details of that, as to who has to do what, have not been hammered out. And it's one of the parts of the decision that's not being
Yeah, but the record seems to indicate that a lot of the growth, shall we say, is because of your client, right?
Oh, absolutely, Judge.
Oh, okay, so, all right. So in terms of maintaining it, it could be 50-50. Let's just say arguably it's 50-50 to maintain this party wall here. But if it's all mostly your growth, what if your client, I mean, Supreme Court was finding out that your client really didn't do much to maintain this wall, right?
So I don't think there was any evidence before the court as to what had been done. The evidence that was before the court as to what was happening and what damage was being caused.
Right.
And it's clear, looking at the evidence, that there was very little conclusive evidence as to that.
Well, they put in an expert who said that there's, with pictures, because I saw them, that there is damage being done to the, I don't know, it was their east wall, I forget, of their building that could cause water infiltration and other problems, and you have to do something. You did not submit any expert report to say that they weren't correct and to dispute it in any way, and the judge, was able to determine that there was potential damage and that you were supposed to do something to prevent that damage. If you wait any longer, they're going to have horrible damage to their building.
So that was the conclusion that the judge came to, Your Honor. But if you look at the expert's report, and I also cite you to the respondent's papers, the expert said that likely damage would occur. There has been no finding of the extent of the damage, and it's important to note because there's an.
But you didn't dispute that there was damage.
Judge, if this was so early on, we hadn't even had an opportunity to inspect the building. So we were just saying it's entirely too early on that we should have and Judge, just so that you know, they haven't established the causation at all, that there's, may I continue?
You have 2 more minutes.
They haven't established the causation, Your Honor. They haven't, their expert says likely damage will occur. Their expert says that if you have a brick wall, you can get damage like this, and ivy can exacerbate it, but their expert doesn't say this ivy did exacerbate it. Their expert does not say to what extent. And the court, in their subsequent findings, goes on to say, I make no finding as to what damage is done here. She specifically says that. I make no finding as to who's responsible for what. Yet I want the defendant or the appellant here to go to the extraordinary remedy of taking down this ivy that's been there for 50 years when there's been nothing. No one has said that within a reasonable degree of expert certainty that this ivy is causing a problem. To do what this judge is telling us to do would not only not maintain the status quo, it would completely reverse the status quo, which is contrary to this court's findings about when injunctive relief should be applied.
Well, how do you approach the situation where, okay, the ivy is on the wall, that's pretty, we see the photos there.
Yes.
If the respondent says, I don't want the ivy there, but you guys are going to say that, no, we want the ivy there, what happens then, right?
Well,
unless that sounds like that's got to be your position, that the ivy is fine. We don't have to take it down because there has been no definitive, report, conclusion that is causing any damage to the wall. What stays up?
Absolutely. And Your Honor, in the very least, we should all be allowed discovery on that issue. In the original motion papers, we said, listen, this motion being made while we have an outstanding application to inspect the premises that hasn't been granted. Judge, I just want to point.
Your buildings are right next to each other. You've been writing letters for 20 years.
There's a lot
Not
of
to mention that there was a decision on this case 60 years ago. It's not like
Absolutely.
this is a new dispute.
No, absolutely. But that decision says we both have a right to enjoy it. And now
Somebody's not
Well,
happy.
somebody, yeah, well,
Somebody's not happy. One side's not happy.
He's not
But we
enjoying
should
it.
have an opportunity to fully investigate and to fully determine what's happening here.
Why-
Even the case, want me to?
Go ahead.
If you look at the proofs performed or produced by the plaintiff in and of themselves, they are insufficient to establish the claims that they are making.
Okay, you have rebuttal time. Thank you.
Thank you, Your Honor.
For the respondent, Nativ Winiarski from the law firm of Cook and Marino, Winiarski and Bittens. Respectfully, the argument I just heard was a complete distortion of the record. There were expert affidavits and expert reports, 3 expert reports, all submitted below, none of which were rebutted or opposed. You just have to look at the record.
Your guy just wants all the ivy off the
Correct.
wall.
We have a party wall.
I don't like it. I don't want it there.
They're encroaching on the party wall, though the ivy and vines are causing damage, and it's putting it in a position where you have a wall which is holding up the
Well, let's take a step back. If I hear the argument, it's like there's been no proof of damages. Well, the way I'm thinking about it, I'm looking at this record, your client says, I don't want the ivy on this wall. So it's not my ivy. You take it off.
That's
simple.
That's completely correct.
Irrespective of damages or not, I don't like this ivy on my wall.
Agreed. 100% agreed.
There's no dispute that the ivy is not your client.
That's
it's
correct.
The other guy's
I mean,
client.
they can keep ivy on their side.
Absolutely.
And then just
They have to take it off the wall, that the party
off of the wall that's
right,
yours.
there's some space between
Yes,
the
there is
buildings,
space.
a garden. Have as much ivy and vines as you like.
Just don't put it on the party wall.
Now, counsel indicated, when I said to her, well, you had no expert affidavit that in any way countered the expert affidavit that your client submitted, and she said, well, your expert affidavit was not as definitive as you might have represented. Now, I looked at it, but it doesn't say that this was causing the damage?
Your Honor, I'd like to read just portions of it. It's page 141 of the record. So he says in paragraph 8, the party wall is entirely covered by vines growing from the neighboring property. This ivy exasperates the weathering process, allowing ivy roots to grow. And he says it must be removed as soon as possible, and the ivy be kept off the party wall. The party wall is deteriorating in multiple spots. Brick is falling, and he specifically says prompt action should be taken to stop the overgrowth because this is a critical structural element of the building, and the failure to do so could cause serious injury to persons or property below.
And this expert affidavit was dated when, Counselor?
This is dated April 19th of 2023. There were no less than 4 interim orders here in which she repeatedly went to appellant's counsel and said, give me an affidavit, something to oppose or controvert this affidavit. And all they did was continually thwart the judge's order and thumb the nose at her and offered nothing. I'm astounded that they're here looking to call Justice Bluth's decision in error and it should be reversed when it was due to their omissions that they gave her no choice. It goes to the fact that, 1, we don't want the vines in the party wall, irrespective of whether it's causing damage. And number 2, it is causing damage. And I'd just like to end with the language.
It's not your ivy.
Exactly. And in the end, I'd just like to end with Justice Bluth's language, which she says, this is not a case just of how much and who pays. The court views this as a safety issue. The court takes safety measures very seriously and does not want to wait so long that a serious or emergency condition develops that the party wall threatens the integrity of the
ivy
building.
is actually wrapping around to the front of the building.
Wrapped around the building, on our roof, on our facade, and now there are leaks inside the building.
Like a sci-fi movie going on here.
Right, and so when she says, "Oh, the judge said that we don't know to which who should be the damage attributable," that's incorrect. But the judge says the ivy needs to be removed, and then we can figure out, was the damage caused by the ivy? Was it caused by repair and maintenance? But in the first instance, it needs to be
down the
removed.
road. That's another set of damages.
Exactly.
Thank you. counsel.
Your Honor, what Justice Bluth did say in her decision of 9/14/23 is, to be clear, the court makes no finding about the exact extent of issues with the party wall, including how much the wall has deteriorated or how much each side will have to contribute to the remediation.
Yeah, that's
of
down the
party.
road. That's down the road in terms of their claim for further damages if there is actual damages to the building itself. But right now, the first and foremost issue in front of the court below and in front of us is the removal of the ivy. I mean, you know, they just want the ivy gone. It's your ivy, cut it back, and that's it. And then in terms of what else goes on, that's for another day.
But, Your Honor, it's a party wall, and it's my right to enjoy the ivy and enjoy the wall as much as it's their right.
Even
and I
if it's,
understand
even if it's harming the wall.
there's no definitive proof. I would
Wait,
point you to the-
wait,
What about
I
the
just-
photographs?
And I just listened.
Photographs are from 2017.
What about that? That he just read it into the record, what his expert said in April 2023, and you didn't give any expert affidavit to dispute that.
You're absolutely right, Your Honor. We did not put an expert affidavit in, and we're asking the court to search the record as to see whether or not they originally meet their prima facie burden, which we respectfully suggest and actually insist that they do not. Judge, I would like to just point you to one specific thing, which I found was very telling, and that was the plaintiff's own brief, where they, summarizing, if I could find it, their own experts report. On page 4, appellant took no steps to repair the wall. However, in early 22, the second engineer's report concluded that the ivy was likely damaging the wall. There's nothing conclusive had been said. They talk about there's having been a failure with the mortar, failure with the joints. Never does he say specifically this is the ivy. He says ivy can do it. He says there's ivy here. We're simply asking, hey, let's actually go and see. Let's take the time. This was done. Do you understand that the summons and complaint was filed in December of 22, 6 months after this report came out? If it had been of such urgency, the summons and complaint would have been filed much sooner. This was filed by a motion for summary judgment, not in order to show cause. Again, lack of urgency. To come now and to describe this urgency, their own experts, their recommendation is this, Judge. Their recommendation is to go look at the wall, determine the extent of the damage, and make repairs. They say, hey, put up a sidewalk shed so you don't have the pedestrians going by. But they don't say, you have to bring this ivy down to me. They say, go look at the wall, determine what the problem is, and make the repair.
Thank you, counsel.
Thank you.
Santola versus City of New York.
Good afternoon, may it please the court. Peter Santola appeals from a denial by Justice James of his application for renewal of his pistol carry permit. This case comes before the panel following the U.S. Supreme Court's decision in New York Rifle.
So that has the proper cause. Bruin talked about the proper cause element in terms of the pistol license, but it didn't address the good moral character standards. So why do you think that Bruin also affects that requirement?
Well, there's two aspects to it. Number one, the Supreme Court in Bruin indicated that there has to be a historical nexus between licensing regulations and the denial of a Second Amendment right.
Yeah, I mean, Justice Gorsuch said in his concurring opinion that doesn't mean that we're saying that every person, you know, in terms of that we're giving carte blanche or allowing people with criminal backgrounds to get a pistol license.
Agreed.
Right?
And what's significant in this particular case, and what I think makes this case significant, most respectfully, is that commendably, after the Supreme Court ruled in Bruin, Governor Hochul convened the legislature in a special legislative session, and the legislature responded, just as Your Honor indicated, and clarified among other things, the definition in Penal Law Section 400.00 of good moral character and made it clear that good moral character requires a nexus to licensing. There were a whole litany of cases that were decided by this court and the Appellate Division Second Department, which were not based upon any nexus between the defendant's conduct.
So we have the case now in front of us, your case here.
Yes,
So
and-
how do you address then the situation where we have in the record here all the various incidents reports, order of protections? I mean, it's kind of a lot in my mind.
In response, Your Honor, I call Your Honor's attention to the fact that the License Division in this case, number one, denied renewal prior to Bruin and prior to the amendment by the state legislature.
Yeah, but it did say when it denied it, there was application was denied also on good moral character.
That's what brings it here, and I'm saying that in the interim, and in fairness to the License Division, it did not have before it the amendment to the law that the state legislature enacted in July of 2022.
Yeah, but that law only expanded or that law defined good moral character, right? Is that what it did, right?
And that's the basis here. And I point out when Your Honor made reference to orders of protection, one, all of these were ex parte. Two, none of them were in compliance with this court's decision in matter of Crawford versus Ally in 197 AD 3rd 27. There was no adversarial proceeding, as noted by Associate Justice Weber in her opinion. The most recent case that this court decided subsequent to my case in Callahan was the Ward case. And in the Ward case, which was decided in October of 2023, none of you were on the panel, in Ward, the applicant who appeared pro se had been arrested. My client, Mr. Santola, was never arrested and never accused of violating an order of protection, and she failed, Ward did, to cooperate with the licensing division. That is not the case here.
There was reference to the New York City Charter, the regulations R5-10.
Yes, and my contention is they're unconstitutional under Bruin because they do not comply. Good moral character applying untested ex parte orders of protection does not comply with Bruin, nor do arrests, nor the ACDs.
When my understanding is you have ex parte orders of protection. I mean, for the individual that's being served upon, they would move to vacate those orders of protections, right? Because if you sneeze the wrong way, you find yourself in a jail cell.
Well,
so you're telling me that these ex parte orders of protection, that your client just took them as it is and didn't challenge them?
He didn't have the benefit of matter of Crawford versus Ally. These were issued ex parte prior to Judge Weber's decision. So what I ask are either of two things: a simple cryptic remand on constraint of Bruin and recognizing that the definition of good moral character was changed by statute, you're done.
Thank you.
If you want to go big, you can talk about good moral character and provide some guidance to the License Division. In any event...
You have rebuttal time. It's okay. Save some for your rebuttal. Thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of the Licensing Division of the New York City Police Department. So even if petitioner had argued the point, there was a more than ample basis for the division's determination that he had failed to shoulder his burden to show that he had the requisite good moral character. Petitioner wants to talk about the Second Amendment, but since Heller in McDonald...
It's by chance the respondents denied it on two grounds. One was good moral character and proper cause, right? It was just...
I wouldn't say by chance. We denied it on the grounds that were available to us at the time.
Right.
We recognized the proper cause as unenforceable. But just to round out the point about starting with Heller, the court says the Second Amendment right belongs to responsible, law-abiding citizens. Even in Bruin, when the court is, by contrasting the proper cause regime in New York with, I think, the majority of other states.
You know, I think what I'm trying to recall the argument. It's funny is that this decision, this determination by the respondents here came down before all the amendments to the good moral character provision, and he says that this requires a remand to them to now consider this in the scheme of the new amendments. How do you respond to that?
This panel should follow the path of Ward, which didn't do that. Because if you look at the Antoniuk case, which we rely on, what it's recognizing is that I think for a century, licensing regimes in this country have required a showing of good moral character. It actually is consistent with the history and tradition of firearms regulation in this country. As to the preemption point, it's made in such a conclusory manner in the petition that I'm not even sure it's preserved, but he starts off with this conflict preemption, but doesn't identify any conflict with state law. Now it seems to be field preemption, but the fact of the matter is that the state law provides that a license to carry in any other jurisdiction is valid anywhere else except in New York City. By necessary implication, that means we get to do our own investigation. We get to promulgate rules pursuant to that. So this idea that there's something problematic constitutionally with the rules, it's not in the case, and it's just wrong.
Is there any variance between the good moral character standard that the licensing division employed in considering this application and the new amendments to the penal law defining good character?
Not for purposes of this case. A reasonable person would know before this case, after this case, that when they come to the licensing division, they can't lowball them as petitioner did here. He complains about hearsay. He complains about a he shed, she shed that ignores that it's multiple independent incidents. It ignores that it's also third parties in the community. But even putting that aside, he had a different solution, even beyond challenging the orders of protection or doing something else when he became aware of these allegations. He could have told the licensing division the truth. He could have said, here's my side of the story, here's the deal.
Charter, the regulations that I mentioned to him, are these grounds for denial of handgun license? These are not applicable now?
They are applicable now,
It's referred to in Ward.
His preemption argument also ignores that the good moral character requirement exists in state law. So even if this court were to say, let's put all of the licensing division rules to one side, the fact of the matter is he still had to show his good moral character. He didn't do that here. He hasn't even challenged rational basis.
The amendments didn't make it, I'm trying to phrase this probably, the amendments didn't make it easier to get over the good moral character for individuals who are applying. It didn't, as my colleague, and I just want to make sure, the amendments didn't do anything to alter the landscape in terms of how you as a person asking for the pistol license to demonstrate good moral character. I mean, it's there. I mean, it just maybe redefined and clarified what good moral character is, but didn't do anything to throw out all years of how we even get to the good moral character finding, correct?
That's correct. And I think the definition also patterns along what had been the gloss from case law for years.
Thank you.
The council party knows this.
Thank you.
Thank you.
Briefly, the license division never afforded me an opportunity to confront and cross-examine the complainant. It was all based on hearsay. In terms of the presiding justice's question about did the change in the law in July of 2022 change the landscape, it did, dramatically. No one disputes the license division here in New York City is empowered to enforce the law, but state law is predominant, and the use of orders of protection, which were never violated, no arrests, much less convictions, no violations of orders of protection. This does not support the new definition which changed the landscape post-Bruin. Simply put, this license division violated my client's constitutional rights. The court, of course, beyond what I said before, could wait for the U.S. Supreme Court's decision in the Rahimi case and then decide and have more before it. Lastly, I called the court's attention to the fact that in the city's brief, they referred to conversations after this case was filed, which were a violation of settlement talks. I respectfully submit it was a low blow. It should not be countenanced. It's improper.
Thank you, counsel.